Welcome back to the show, everybody. We got a good one for you today. The SEC responds back to the Ripple claims. Feels like we're watching an incredible tennis match. And the U.S. bill for crypto introduced to Congress. Let's go ahead and roll that beautiful intro. Here we go.
This is Digital Perspectives with Brad Kimes. Subscribe for new content notifications. Now, here's Brad Kimes. Come on in.
Welcome back to the show. You can follow me on Twitter at BackupBradley above at the top of the screen, and everything that we're talking about here today. We're almost at 1.7 trillion, $1.688 trillion for the crypto market cap collectively. Bitcoin is raging right now at $54,831, and that is impressive. It is over $1 trillion market cap again, and that's important to recognize that 1 trillion of the 1.68 trillion here belongs to Bitcoin, like it or not. Ethereum coming in at $1,815.26, and it's coming all the way down to the number 7 spot, courtesy of the dereliction of duty of the SEC, and we're about to get into some of that. 46 cents, XRP 0.4656. We're down almost 3% on the 24-hour and up almost 4% on the 7-day. How about that one? Let's go ahead and see what the range is right here today. We're looking like we're ranging between 45.94 and 48.82. So between 45 and 48 cents. Remember, we need to get above that, 47 to 50 cent range and stay there and be able to hold. And if we can, then we can start really talking about some big numbers. And by the way, in my next video, I'm going to have an amazing breakdown of technical analysis from Crypto Wizard. I think you're going to want it. They have over 5,000 paid subscribers in a group. This guy is serious business with his TA. And we're going to have a great breakdown for you on price and what to look out for coming up in the future. So looking at this right here from DJ Peter Vass, this is Galaxy Digital is launching a Canadian Bitcoin ETF tomorrow. That is incredible to me. I mean, wow. And shout out to Galaxy Digital, Mike Novogratz and everybody there. I had a chance to interview one or two people from Galaxy Digital for Cryptonaires the Film, which, by the way, is really done. We have someone who has picked the film up. They are going to distribute the film. We don't have a release date from that company yet, but as soon as we do and we're able to officially announce it, we'll be so glad for all of you to see it. And by the way, the one thing I can tell you is everyone will get to see the film for free. How about those apples? So congratulations to Galaxy Digital. Things are getting bigger. And things getting bigger. Speaking of that, Rob Gronkowski, that's right, the Gronk baby, special announcement, NFT collection for the Gronk. NFTs are not a trend. I really do not believe this. This is not financial advice, but NFTs are reviving collectibles and memorabilia and intellectual property. And I, for one, as a musician, songwriter, and producer for 30 years, have to say this is an incredible moment for the internet and artists and people who have intellectual property, patents, paintings, you name it, or collectible sports memorabilia. That's why I keep telling you guys about the idea of Unstoppable Domains and their March Madness right here. If you click at the NFT sales, you're going to see tons of NFTs. And you know what? We've all been buying a ton, and they're not all $100,000. So don't freak out. But look, somebody's got the coin to get it. Hotels.crypto? Are you kidding me? I mean, it's remarkable. Look at how many have sold since yesterday. A lot of these were available. Just yesterday afternoon, travel and transportation for the first time were made available. And look how many got scooped up. That's remarkable. By the way, somebody got Maui, Hawaii. No, they didn't get Maui, Hawaii yet. And you better get it before I do, because I tell you what, I like that one a lot. I shouldn't have said that. He's going to get it. Oh, that's incredible. Anyway, this is really great, the NFT collections. Let's keep moving. It is very exciting. This is from Digital Asset Investor. Shout out to him. This is from the Global Investor Conference from Link2. By the way, if you're not into that, there's still another day of the conference, and this is the kind of people they have there. Tim Draper answers and weighs in on the Ripple lawsuit. Let's hear this quick clip from Tim Draper. I just love it. And shout out to Digital Asset Investor for the great question here.
I think we're going to find a more balanced. I think it's going to, those things can go either way, but I think that there will be some sort of middle ground and it will wash over. I think there'll be something where they kind of go, okay, let's solve it in this way, because you don't want to lose the ability for Ripple to operate. They're the bank rails for a lot of transactions. So I don't think that people are going to. I think they'll recognize there's real value.
Ripple are the bank rails for a lot of transactions. From Tim Draper. Shout out to DAI one more time. That's a great clip right there. And they really are. And look, we just saw the information about, MoneyGram winding down. Well, look, that don't lay long. Look at this. Stellar Base Lightnet partners with MoneyGram in Southeast Asia. Well, how about that? In a relationship, when two people break up, they say the best way to get over somebody is to get underneath somebody else. That's what I heard. And it looks like we're seeing evidence of that here in the business world. So shout out to XLM. That didn't take very long. Hope somebody got a shower. Bond Crypt XRP, SEC attacks. SEC attacks key Ripple defense. I'm sorry. Calling them legally improper in a new letter, the SEC breaks down two of Ripple's key defense strategies: due process and fair notice. The fair notice is a key cornerstone of Ripple's defense. Let's take a look at the article if I can stop laughing. This is no laughing matter. Okay. After Ripple filed its response to the SEC amended complaint, the U.S. District Court, Southern District of New York, a few days ago, it was the securities regulator turn again. As a document uploaded to Court Listener yesterday shows, the SEC didn't take much time in responding. And in layman's terms, the SEC is, they're pissed. So in the letter to Annalisa Torres, the SEC asked the court to deny Ripple's fair notice defense and to dismiss the motion for leave to file to dismiss the individual claims against Brad Garlinghouse and Chris Larson. The SEC claims that Ripple is attempting to avoid liability by shifting blame to the agency. As attorney Jeremy Hogan, who we're all really grateful for, explained in a tweet, the SEC apparently wants to eliminate Ripple's fair notice defense because they are worried about it. And that is really the truth. It would be a blow to Ripple if it is removed. The SEC wants it done quick because there are facts they don't want to come out in discovery, Hogan said. And I think this is absolutely right. This is right spot on here. The SEC understands that if they have to reveal even further that other crypto exchanges before suing Ripple reached out for clarity about Ripple, it is going to get ugly. And that's the kind of thing that would absolutely come out in a full jury trial. As CNF reported, the fair notice is a key cornerstone in Ripple's defense because Ripple found out that the SEC was approached in 2019 by a major crypto exchange, or perhaps multiple exchanges, about the status of XRP because the SEC failed to make a classification for years, even though FinCEN did so back in 2015. To strengthen that argument, Ripple had also added new arguments in its response to the SEC's amended filing, as Hogan explained. A lot of new information is added to AF defense, number 4, related to due process and fair notice. Do not listen to anyone who says arguing you got away with it for 8 years is not a good defense. The due process argument is key to this case. To puncture this very very strong defense strategy, I guess they were looking to say, the SEC states in the letter that Ripple's defense is legally improper and claims that it is not required to issue warnings about violations in the midst of a non-public investigation. Rather than acknowledge its own obligation to follow the law, Ripple instead posits that the SEC staff has an obligation to affirmatively warn industry participants about violations of other participants, even if the staff is in the process of conducting a non-public investigation, a requirement that does not exist in our legal system. In addition, the SEC argued that the settlement with the FinCEN and the vacant comments to the unidentified exchange do not provide a legal basis to dismiss the complaint. According to the SEC, Ripple is not exempt from compliance with securities laws or other applicable laws merely because the government, legal counsel, and anyone else has classified it as a security. In this regard, the regulator urges an affirmative is improper and should be stricken if it is legally insufficient basis for precluding a plaintiff from prevailing on its claim. None of these facts, even if proven, would set forth a legally valid defense to the SEC Section 5 claims against Ripple. Further, the SEC submits that only the Howey test is determinative of security or non-security in this regard. The SEC argues that Ripple essentially funded its business by selling the digital security XRP. Ripple's argument is in essence that the term investment contract as defined through decades of case law is void for vagueness. However, the argument has been repeatedly rejected by courts that the Second Circuit Court has at least twice rejected the argument, and at least twice district court in the circuit have specifically rejected the argument in context of applying to Howey to digital asset securities. Here, Ripple essentially capitalized its entire business by selling a digital asset security to the public while promoting to investors the potential for profits based on Ripple's future efforts. Yet Ripple now claims surprised that the SEC filed this enforcement action. I guess when you sum this all up, it's all still just a very big mess. And it does appear that what the comments from Jeremy Hogan are spot on, I believe, as he has been through this whole process, which really is they do not want more of this SEC does not want more of this information coming out. They don't. Because if it does, it's just going to get worse, right? So, it's the 8 years. That's what you can't really get past. And I believe, honestly, that, I believe that this gap of time was done. I had a great conversation with Big Skinny yesterday. Now, you talk about two people who can speculate something. Well, me and him get going on something. We can speculate the hell out of something. And all I can say is, we don't know what the outcome will be. I know what I want it to be, right? And I hope that XRP comes out of this thing as a currency or a virtual convertible currency, just a tick below legal tender status, and allows it to function just as it has done this entire time up until now. But we'll see what happens, obviously. But, one of the things that we tripped up in our conversation on was the idea that, will we see this case be settled out of court before Gary Gensler is actually confirmed? Because we know that Gary Gensler is very much in the frame of mind that he believes that it is a non-compliant security, even though he recognizes the role of XRP is to work as a bridge currency, and he says that too. So it'll be interesting to see how this does shake out, and it'll be interesting even more to see if this actually gets a settlement summary judgment before Gary Gensler actually takes the helm. And if it doesn't, it'll be even interesting to see what his impact on the case may or may not be. So we'll see what goes on there with the judge. All right, now, this is from 432 Hertz XRP. Awesome. Great to hear from you, 432 Hertz U.S. lawmakers. And shout out to Steve Gilbronson, who I believe sent this to me as well. And if not, shout out to you anyway, Steve. U.S. lawmakers introduced bill to clarify crypto regulations. Now, this got interesting for a minute, and we will follow up on this because I'll show you. But basically, it goes through this, and it says that Congress may soon try to clarify digital asset regulation in the U.S. That could certainly be helpful for the judge and everybody involved in this case. It goes through and lists everybody there, and it should be something that works between the SEC and the CFTC alike. The ultimate goal in the legislation, called the Eliminate Barriers to Innovation Act of 2021, would be to clarify when the SEC has jurisdiction over a particular token or currency, when it is a security, and when the CFTC has jurisdiction when it is a commodity. Yeah, let's go ahead and get that one figured out. Here's all I can say about this. Under the terms of the bill, Congress would create a working group within 90 days of the bill's passage, composed of the SEC and the CFTC representatives. Non-governmental representatives will come from financial technology companies, financial services institutions, small business. So you can see a consortium would be put together here, right? Okay, and then within a year, this group would be required to fill out a report analyzing current regulations with the impact of how primary and secondary markets, and you know the rest of the drill. I come down here, and this is the part that I see that gets like, wait a minute. The bill was originally supposed to be introduced Monday and considered under a voice vote by the full House of Representatives, indicating broad bipartisan support. According to Representative Don Beyer, he says, but it was pulled due to procedural actions taken by the Freedom Caucus. What? What's this all about? Is it news if it gets pulled? I mean, did it get pulled? Here's what I did. I just tagged, and I'm asking all of you to politely tag Warren Davidson or retweet this and tag him. And so we can politely have this tweet addressed so we can find out. And I said, Warren Davidson, can you give us an update on the newly introduced crypto bill to Congress? We appreciate your hard work on this matter. As a YouTube influencer with almost 100,000 subscribers, I invite you on my show and offer my support to testify in Congress. And let's hope, he has been such an advocate for this space. Let's hope that we get some attention from there, and please retweet that so we can actually hopefully get him on the show and try to find out. I believe that the Dems have all the branches of government, the executive and the House and the Senate, so we should be able to get this through without an issue. So we'll have to see what goes on here, and maybe we just get that DCA Act, the Digital Commodities Exchange Act, back on the table, because we know for a fact that Brad Garlinghouse was absolutely bullish about the DCEA. So maybe we could actually get that reintroduced as well. But the chance to talk with Representative Davidson would be amazing. So shout out to him for all his efforts, and everybody else, Tom Emmer and everyone else that's been a part of the crypto movement there and awareness in Congress. And hopefully we will hear something soon. That's going to do it for me. Make sure you hit the like and subscribe. Leave a comment below. Make sure you share with somebody you know. Guys, don't forget, this is tax time, and when it comes to crypto, don't mess around. Clinton Donnelly is the best man in town, the crypto tax fixer. Link in the description, link in the comment section, just like all the other products and services I have. Make sure you check them out. And more importantly, they are vetted, trusted links. I'll catch all of you on the next one.